Here locally, we are in the midst of legislative session. As many of you know, we're in the midst of what's called crossover, and that's when bills cross over from the House to the Senate or the Senate to the House. We're also during a time where both reps and senators are introducing resolutions, and though resolutions are a little different than policies, they tend to be more radical. They tend to make bigger demands, and so I would keep a watch out. I know that there are 2 resolutions on deck that speak to our issues, both buffer zones and disclosure specifically. There's also a bill that the Farmers Union is advocating for on on-farm mentoring, which would create a funding stream to support peer-to-peer learning for farmers across the state. So I think that's really important. And the possibility exists that the House could be entertaining a bill to restrict pesticide use on school campuses. So if you're interested, I would encourage all of you guys to email Rebecca at centerforfoodsafety.org. She manages our policy watchdog email list, and so you'll get emails on a weekly or sometimes twice weekly basis knowing when you can submit testimony and testify and participate in the legislative process. And again, civic participation is this critical link in what we're doing. We're also gearing up for elections this summer. I really encourage everybody. I know we're all kind of watching in horror and hope at the U.S. presidential election, but it is our local elections that will actually probably have a more profound impact on our everyday lives here in Hawaii. And there are some races that we're watching really closely, which are in some ways going to be a referendum on Hawaii's food system. Candidates that are being propped up and backed by the agrochemical industry, running against some of our fiercest allies in office. So if you're interested in getting involved, the Center for Food Safety has a super PAC. It's called the Center for Food Safety, the Hawaii Center for Food Safety Action Fund, and you can find us on Facebook. Finally, the joint fact-finding was released last week. For those of you who don't know, this was a year-long sort of research endeavor for the island of Kauai. It was paid for by the Department of Agriculture and the County of Kauai to kind of review all of the publicly available data on human health, environmental health, and pesticides and GE field trials on the island of Kauai, and it sort of makes recommendations at the state about what they should do to address what is a continued issue both on that island and statewide. Despite the chemical company's attempt to spin the joint fact-finding, it was actually incredibly powerful validation of all the work that we've been doing here as a community over the past 10 years. They specifically recommended that the state adopt mandatory disclosure, buffer zones. They asked the governor to put together a pesticide task force. They said that the evacuation of Waimea Canyon Middle School could not have been related to stinkweed. And they said that we just don't collect the health data that we need to collect to make the connections between human health impacts and pesticide use, but that in no way suggests that these pesticides are dangerous. And they reference sort of the abundant medical literature that shows that pesticides are dangerous for human health and the environment. We're trying to continue organizing people to engage around the joint fact-finding officials and really helping their elected officials. The joint fact-finding concluded. We do know that the chemical companies are pounding the halls of the legislature representatives. They couldn't find that there's this link between health and pesticides, so everything's okay, but that's actually not what the joint fact-finding concluded. So if you're interested in participating and lobbying, please reach out to our office. Again, Rebecca at centerforfoods.org is our policy intern, and she can point you to opportunities for engagement. So with that, another big part of our work here is with litigation, and so I'm really excited excited on the line today to talk to you a little bit about all three cases that are currently pending in the Ninth Circuit Court of Appeals. And we might have Sylvia Wu on the line too. I know many of you guys have worked closely with Sylvia over the past couple months, and she's been just an amazing ally for our office in terms of drafting and reviewing legislation. So with that, please help me welcome George Kimbrough.
Okay. Aloha. Thank you, Ashley and Danya. Thank you for having me, and I'm happy to be with you all today. Good afternoon. As Ashley indicated, it is a momentous day today. I guess we can use whatever pun comes to mind as to the Dark Act. It's darkest right before the light, it is indeed the sun is shining here in Portland, Oregon, which this time of year is a pretty rare occurrence, and I think it definitely fits the mood. So an important victory, and important always to note those things, we think, when they are won. So, but today I'm not here to talk about genetically engineered food labeling or what's happening in the U.S. Congress, but rather the 4 litigations that are ongoing in the U.S. Court of Appeals for the Ninth Circuit involving the Hawaii County ordinances that I'm sure most of you folks on the line know quite a lot about. So for purposes of this overview, I am going to assume a basic level of knowledge with regards to some of the facts and the ordinances in question. And then if I assume too much, which definitely can happen, we'll have time for question and answer as was indicated, and I'm happy to follow up and try to explain any more as possible with regards to the current status of the cases. But I'll start by just giving a brief overview. And I should say that in all of this work, I want to recognize Earth Justice as our partner in crime in this litigation, co-representing a lot of the local groups there, as well as the national groups that we represent in many of the litigations on genetically engineered crops, including the Hawaii cases. So just going in order of the cases, the first one is the Kauai litigation, and this is the litigation over the bill known as 2491, or later Ordinance 960, that was passed, having to do with regulation, improving regulation, and creating buffer zones for pesticide spraying and locations of genetically engineered crop planting. That litigation began in January of 2014, soon after that bill was passed, late the year before, and at the district court level went through August 25th, 2014. So in that case, we intervened on behalf of local citizen groups, Surfrider, Pesticide Action Network, and also Center for Food Safety, and moved to assist the county in defense of that ordinance. This is important. It's important to note that in the Kauai litigation, the County of Kauai has been, they did hire a Honolulu law firm to represent that county, since the county government itself, the mayor's office, was conflicted out of representing the county ordinance since the mayor had vetoed that ordinance. But the law firm that they hired has done, I think in our view, a vigorous job, and that law firm is Miller and McKinnon, there in Honolulu, representing the county and working in defense of Ordinance 960. So we were granted intervention by Magistrate Judge Curran in that case, and then worked with the county in defense of that ordinance that was attacked by Syngenta and the other plaintiffs in the case on 13 different grounds. Those would be state as well as federal legal arguments. And as I mentioned earlier, in that spring of 2014, maybe June, we were granted intervention by the court. Over summer of that year, we briefed the merits, and on August 25th, we got that decision, unfortunately holding against us on implied state preemption grounds. The Kauai ordinance was wholly preempted on those grounds, and the court did find in our favor on the federal preemption arguments that had been raised by case. So what happened next? We filed our notice of appeal September 24th, 2014, and since that time we have been litigating that issue
in front of the Ninth Circuit Court of Appeal was completed in that case on May 11th, 2015. So it's been done now for almost a year, and we've been awaiting assignment of an argument calendar. That is, when the Court of Appeals decides when they're going to hear the oral arguments after the written briefing is done in a particular case. And we're still waiting for final confirmation of when that argument will be held. I will say that what is at issue in the Kauai appeal is the state preemption issues, namely this decision below by the district court that state law, even though it didn't say anything about genetically engineered crop regulation or anything about pesticide buffer zones, still impliedly or implicitly preempted Kauai and other counties in Hawaii from enacting ordinances like Ordinance 960 that would improve regulation in those areas. And we've asked that the appellate court to reverse that decision, or in the alternative, to send that decision to the Hawaii Supreme Court for the Hawaii Supreme Court to decide that in the first instance, because it is an issue of state law, and it's an issue of state law and one of first impression. So we think it's proper that the state court, the highest state court, decide that issue rather than a federal district court judge, federal magistrate district court judge. So that's the current status of the Kauai case, and I will say again that the county has similarly appealed that decision and briefed it to the Ninth Circuit, and similarly asked that the court decision be reversed and vacated, or on the alternative also has sought that certiorari be granted, that is, that the case be sent or certified to the Hawaii Supreme Court for this state law issue to be decided. The second case that's currently in front of the Ninth Circuit out of the Hawaii county cases is the Big Island appeal. That is the industry's challenge to the ordinance passed that same year on the Big Island. Case is known as Hawaii Papaya Industry Association v. County of Hawaii. And in that case, it started a little bit after the Kauai litigation. Again, I'm assuming a fair amount of knowledge with the facts of all of these ordinances and how they were enacted. I'm sure many of you had a lot to do with it and are very well ensconced in it. But essentially, this ordinance was a prospective prohibition on the growing of genetically engineered crops on that island going forward, with an exemption for certain crops in certain instances. And its main purposes had to do with contamination of organic farmers and preventing the other harms that are associated with the growing of genetically engineered crops. So in that case, we also immediately moved to intervene in the district court level, representing, again, local farmers and groups on the island, on the ground, as well as our allies in the national work on this, and our own organization. And we were denied intervention in that case, in that instance. We were allowed to file a friend of the court brief to the district court and to participate in the oral argument that was held in October of 2014. The court decision, again, by Judge Curran, it was issued on November 26, 2014. I should say, in addition, like in the Kauai case, unlike in Maui, however, we did have the county of Hawaii that vigorously defended the ordinance in court to the district court, filing briefs alongside us and working concurrently with us in defense of that ordinance. Unfortunately, Judge Curran, the same judge as in the Kauai decision, issued a very similar opinion, essentially following the reasoning of the decision he had just issued just a few months before in August of that same year, and again finding in favor of the challengers on state preemption grounds, finding that the ordinance was impliedly preempted, again, even though there was no instance in any existing Hawaii law that mentioned genetically engineered crops, let alone these specific ways that the county sought to improve their regulation, finding that counties could not act in this area and only state law could regulate such matters. And on federal grounds, he found, again, in favor of defending the ordinance, finding that the law could be preempted in very select circumstances, but otherwise rejecting resoundingly the arguments from the plaintiff biotechnology organization, the umbrella group and trade group that represents the biotech industry, as well as the other plaintiffs, that the law was, in addition to preempted by state law, also preempted both expressly as well as implicitly by federal law. So he rejected those arguments again in the main with limited exception. So the notice of appeal in that case was filed January 6, 2015, and it's important to note that we're involved in that case in defending that ordinance because during the time from when the district court decision was issued until the notice of appeal, we actually were asked to represent the county directly along with Earth Justice in that litigation. So our client is the county itself, and we've counseled and litigated the entire appellate proceeding on behalf of the county directly and the county ordinance directly. So that briefing took place over summer and fall of 2015 and was completed October 1st, 2015. And so we are currently, just like in the Kauai case, waiting a final date for when that argument is going to be scheduled. I will say, so there in that case, that's the county defending that ordinance, no defendant interveners, because we're obviously representing the county directly in that case. The plaintiffs in that case initially cross-appealed the federal issues that they lost in front of Judge Curran to the Ninth Circuit, but during the course of the Ninth Circuit briefing, they dropped their cross-appeal of those issues. So what is live then in this, what is at stake in the appeal of the Big Island case are again very similar overlap with the state implied preemption arguments as to whether state law allows counties to enact ordinances in this manner, the same as the Kauai. But in addition to that, some issues as to whether the district court was correct in rejecting the plaintiff's federal law claims as to the ordinance being preempted, although many of those are not at issue because they dropped their cross appeal of that, of our victory of that below. So that's the Big Island appeal. And again, just like the Kauai, we have some news on a tentative date for argument, but we don't have it set in stone yet. Still waiting the oral argument for what's already been done as far as the appellate written briefing in that case. The next two cases are the two Maui cases. I'll call them Maui Appeal 1 and Maui Appeal 2, but they're interrelated. The first one is, so this is, of course, the ballot initiative, the great victory on the ground there that I'm sure many of you were involved with over Monsanto and spending record amounts of money. This is an improvement on the regulation of genetically engineered crops, prohibition on their growing in the county of Maui, including Molokai there in Hawaii. And in this case, again, we moved to intervene in this case on behalf of local citizens groups, including groups on the ground that would be directly affected by the spray, the pesticides being used on these fields in Molokai, especially, as well as our own organization and others there. And another group did as well, the Shaka group, represented by separate counsel. And during the intervention hearing in that case, Judge Curran allowed the Shaka group to intervene and then denied us and the people that we represented intervention in that case. And so that's the first appeal, that decision, the denial of our intervention. Intervention standards essentially are that whether or not the existing parties in a case will adequately represent your interests. So if I want to defend an ordinance that our members work so hard to enact, I have to, and someone, Monsanto, for example, sues challenging it, I go to the court and I say, the current parties don't represent my interests. The plaintiffs, these chemical companies suing this county, they don't represent my interests. That much is apparent. They don't claim to. They obviously want to overturn this. I want to defend it. The county, they don't represent my interests either because they have to represent everybody in the county. But my interests, what we represent, are narrower. They're more specific and focused on this particular issue, genetically engineered crop oversight and pesticides and improving their oversight. And we also represent particular members of this county that are directly affected, and therefore my interests are different. And that's normally how that analysis goes. That's how it went in the Kauai case, as well as the Big Island case. in the Maui case, Judge Curran compared us to the other proposed party, Shaka, and said, well, if I let in them, I don't have to let in you. And we think that was wrong on the law. That's not the way the law of intervention applies. So we appealed that decision to the Ninth Circuit, and we briefed it. We appealed it on December 15, 2014. I'm sorry, we got that decision on December 15, 2014, the denial of our intervention in that case. We filed our notice of appeal right before Christmas, December 22nd, 2014, and we completed briefing on that July 9th, 2015, and we're waiting for the argument. And the question presented in that case, very discreetly, as opposed to the merits of the Maui ordinance itself, is just specifically, was the court correct in denying us the right of intervention to defend that ordinance by comparing us not to the existing parties, but instead to another proposed party. So it's a pretty clean legal and discrete legal argument and issue. And obviously, practically speaking, it's interrelated with the current ongoing appeal of the Maui merits, which has, of course, not been standing still. It's been moving along in the meantime, which I'll talk about next. And so I think the interplay between the two of them is pretty interesting and novel, and it'll be really interesting to see how the court deals with that, assuming that we win in one or both of those appeals. So one thing I wanted to highlight is that unlike the other two cases where you had the county governments of the island of the counties of Kauai and Hawaii counties that vigorously defended their ordinances, the Maui county government made no effort to defend their ordinance at all. At every turn, at both the district court litigation as well as in the appellate litigation at the Ninth Circuit, they have gone out of their way to essentially say, we take no position on anything. They have basically waved a white flag and made no effort to defend the ordinance, which obviously was very disappointing. I think it would be quite an understatement. All the more reason that you would think a court would want to have all the parties that do care and do want to defend and have a right to defend a law be a participant of a case, you would think, but nonetheless. That's Maui Appeal 1, and again, briefing is completed as of July of last year, so we're now kind of waiting for that to be scheduled. The second one is the current ongoing appeal of the merits of that decision. Once we were denied intervention at the district court level, we were allowed to file a supplemental brief, and Shaka was allowed to defend the ordinance and did vigorously. And they also asked for a different judge. Since Judge Curran was a magistrate judge, they had the right to ask for a different judge, which they did. It was given to Chief Judge Mulway there at the District of Hawaii, and she issued the decision on June 30th of 2015 on the merits in that case. Unfortunately, the decision was in favor of the challengers, Monsanto and the others that had challenged that ordinance, on all grounds, on both state implied preemption grounds, that is the same kind of state preemption grounds that Judge Curran had ruled on in the Syngenta case and in the Bio case, the Kauai and the Hawaii litigations, but also on federal grounds, finding that in addition to state preemption, that the ordinance was also preempted by both expressly as well as implicitly by federal law. So it was a loss on all of those grounds. The notice of appeal in that case was filed soon after on July 27, 2015. Now, the county of Maui, since they're not defending this ordinance, did not file a notice of appeal. Just the Shaka defendant interveners filed this appeal. And because of that, Monsanto and the other plaintiffs in the case filed a motion in the appellate court arguing that Shaka could not proceed with their appeal absent the county also appealing the case. So that was similar to a motion to dismiss. And that briefing took place over winter, and the Ninth Circuit mostly denied it on February 4th of 2016, saying that the challengers to the ordinance could raise it again if they wished during the merits briefing, or that they would consider it again during the merits briefing, but they weren't going to kick the case out at this juncture without completing the briefing first. So again, we filed a brief in support at the appellate level, as we did below. We were limited, since we're not a party in that case. given the concurrent appeal of the intervention denial. But we did file a brief that was December 7th, I believe, of last year. And the briefing is not yet completed. Monsanto just filed their opposition brief maybe a few weeks ago, and Shaka has one more brief that they get before the briefing to the Court of Appeals will be finished in that case. So what is teed up in that case? What's at issue? What will the Ninth Circuit decide in the Maui litigation? Well, as I said, I think it's both the state preemption issues that are with the Kauai case and the Big Island case, but also these federal issues of federal preemption of county ordinances, not just in Hawaii, but anywhere really, given that it's not a difference having anything to do specific with Hawaii state law. So any county and the interplay with existing federal law or existing federal standards. And those issues are all teed up in that Maui appeal. And I think there's a lack of clarity as to what would happen on our intervention appeal and the merits. Obviously, what we would want ideally is the ability to have the case be sent back and to participate on the merits as a full party. But those appeals have been moving concurrently, so there's practical realities in that, and I think it will really depend on what the court decides as to the merits of that case, as well as our intervention appeal. So that's the overview. I think with regards to the timing, one thing I can say is that a few weeks ago we received a tentative order from the Ninth Circuit that asked if any party in the case had any conflicts with these cases being heard, or three of these cases, the ones that have finished briefing, the intervention denial in Maui, and then the Big Island, and then the Kauai case, being heard there in Hawaii, in Honolulu, the week of June 13th to the 17th during the summer. And the Ninth Circuit normally sits, in various cities across the western United States. Most cases in San Francisco, that's where the main court is, but they have courtrooms all over. And they sit twice a year in Honolulu at the law school there. And so those are particular calendars. And so this year, 2016, they had a sitting just recently, last month in February, and they have another sitting in June. And so they essentially were giving us a heads up that it's likely that these cases will be calendared for this week in June. Do you have any conflicts for that? So based on that, we can, I think, intuit from that order that it is likely that the cases, all four of them, will be heard at the same time that same week, and it will be this week in June of this summer. So I think I'll stop there, and we can see if anybody has any questions.
Okay, great. Thanks so much, George. We do have a few questions. First one we'll start with is, what is the most impactful or useful thing or things that the public can do over the next few months to help support these cases in being successful?
Oh, that's a good non-legal question. I don't know if I have a good non-legal answer. I mean, I think it may be some of the other prongs of our Swiss Army knife, as Dania said, although I think maybe we should update that to, have you guys seen this Echo? It's kind of an app-like thing that when you talk to it, it does 17 different things at once. Anyway, but I think as far as the cases go, the court's going to decide them based on the legal arguments. So I really don't think there's much there. Obviously, the movement in Hawaii it's such a special place, such an important place. It's ground zero in every good way and in every bad way. And so, things are going to go on regardless of the outcome of these cases there in Hawaii. And I think continuing to move the ball forward and continue to doing the good work, the educational work, the outreach work, and the campaign work, that's so important and needs to continue. So that's what I would say. But it's probably a good question for Ashley.
Okay. Ashley, if you want to jump on, you're welcome to. If not, we'll keep moving along. How how do you see the Ninth Circuit viewing this is a question from Jeffrey Bronfman. How do you see the Ninth Circuit viewing the conflicting decisions by Judge Curran and Judge Mulway on federal preemption?
Well, I hope that they agree with Judge Curran on some of where it's helpful to us. Obviously, we're vigorously arguing that he's wrong in many ways. I don't know. I think they'll have a holistic view on the questions, and hopefully they'll look at the legal arguments on their merit, not so much as to the discrepancies. But I think on this particular point, it is helpful to us that Judge Curran got some things correct, and so to the extent that we obviously have pointed that out at every term, as Shaka has as well, and hopefully that'll be helpful to us. I think we've also tried to underscore the great stakes here on some of these issues and these questions of first impression, and so hopefully that will also be something that they'll take very seriously and consider.
Okay, Jeffrey, I'm just going to unmute you and see if you want to follow up.
No, that's fine. That's what I want to know.
Okay, great. Muted again. Okay, on to Lease Deals question. When do you anticipate a firm scheduling of specific hearing times and dates during the June window?
Usually it's about a week before the argument is when you find out. About a month before we'll find out for certain. I should say a month before we'll find out for certain what day and time and all of that each argument will be. And then a week before we'll find out who the judges are. So I would say we still have a little ways to go.
Okay. And another question from Elif. Would there be any implications for the court cases if the state acts on the joint fact-finding group's recommendations for state actions such as buffer zones?
Maybe. I mean, I think certainly, law is a moving target, and so to the extent, the DARK Act today is a great example. You have a new law that could preempt and then moot existing litigation. So, if Hawaii passed a law that said that counties were expressly preempted, then that could obviously moot the cases that we've been arguing about a lot of these preemption issues in an implicit way. The fact finding, that's a little bit different. I don't think so. It's regulatory in nature. It's not a new statute. I think I would be more concerned if a bill pending, as we have seen in years past and this session past, that would expressly preempt counties or would offer more teeth to the implied arguments. So we always have to be vigilant about that. But as far as the state taking regulatory action based on the fact-finding recommendations, I think generally that's probably a good thing, and at this juncture I don't view that as a significant risk.
Gotcha. Okay. A question from Craig Molina. What are the possible implications of these decisions on the greater population on the mainland and other movements facing similar issues, fracking, etc.? Basically, why should people outside of the outside of Hawaii care about this?
Yeah, I definitely think that they should. I mean, I think the cases are raising questions of first impression, both under state law, but also under federal law. Hawaii has been the leading edge of the sword on this issue for all reasons, good and bad, that we're aware of. The chemical companies are there. We have amazing communities, folks on this call doing such great work there. Those are the two basic ones. And I think with regards to the state law questions, I think it would matter to folks because they would apply by analogy in certain instances. There are many states that have general laws that regulate, plant pests and noxious weeds and pesticides generally, and they haven't had litigation and judicial decisions as to whether those laws, despite never saying anything about genetically engineered organisms, implicitly cover all regulation of genetically engineered organisms such that counties can't improve things, cannot take action on behalf of their citizenry. And I think, we just had a case here we won in Jackson, Oregon, where there were arguments about existing state law. Here it was the right to farm law that the challengers had argued preempted the county ordinance that prohibited the growing of genetically engineered crops in Jackson County. and we succeeded in that litigation in getting the district court to agree with us that their argument was wrong and that state law did not cover these issues. These impacts were specific and counties could regulate them. They were different than things that were covered by this existing state law. So I think the state law issues resonate and should matter more broadly than Hawaii as an example, good or bad, both legal and extra legal. So I think people are definitely watching for that reason. Then more specifically, the federal law issues obviously technically matter more than just analogy. They will bind. The Ninth Circuit covers all the West. It's the biggest court of appeals in the country, so it's everywhere from Arizona to Alaska and everywhere in between, Montana, Idaho, Washington, Oregon, California, Nevada. So, Hawaii, so it's a really big piece of the United States. And the decision, whatever decision they make as far as the federal preemption issues that are teed up in the Maui case and to a lesser extent in the Big Island case, will bind the entire Ninth Circuit. And it will be an example to the other circuits on these questions of first impression, because no court has dealt with these issues before these cases. And so I think for that reason, both legal and extra legal, the issues certainly should really matter for folks that work on this and care about these issues far beyond the shores of Hawaii.
Thank you for that. A question from Arya Vrilia. Does the Constitution not give the counties the right to protect their environment and the health of their inhabitants? I'm assuming she's just meaning the Hawaii state constitution.
Yeah, I think the Hawaii Constitution is a really great one. Comparatively speaking, it's it definitely enshrines public trust duties and public trust rights for natural resources for the citizens of Hawaii going forward. So that's the good news. The bad news is exactly how that is fleshed out has yet to be decided, but that's one of the reasons, like I said, that in all of the litigations, and I think I forgot to say this about the Maui case, in all of the litigations, we are trying to get the Hawaii Supreme Court to decide these issues. And we think that these are really important state law questions. They need to be decided by the highest court in the land of judges that are experts in Hawaii state law and the Hawaii Constitution, and not by federal courts in the first instance. That's normally the way this is done, and so I think that would be one issue that I think we would welcome and we would want the Hawaii Supreme Court to weigh in on.
Okay, great. I'm going to unmute you, Arya, see if you have any follow-up questions to that. Are you there?
Yeah.
Say that again? Oh, can't really hear you, so we'll
Hello.
keep moving. So I think some of these questions might be mixed between you and Ashley to answer, but what work is being done currently to formulate laws to mandate pesticide drift testing for downwind plants and homes, schools, as well as bee pollen and honey testing and soil runoff testing, especially on larger high-use farms, by a separate agency other than the Department of Ag?
Yeah, I don't know. I think that may be a better question for Ashley. I guess from our perspective, as far as work being done on a local level nationwide, I can say that just like in Hawaii, a lot of what we do is to try to provide pro bono legal advice to citizen groups across the country that want to enact, ordinances and or state laws that improve the situation in their areas locally. And so, that involves writing a lot of model bills, which we have, and improving them, updating them, and then trying to provide whatever assistance we can in the legislative process and or the ballot initiative process in that way, providing the legal advice to do the writing that's needed in order to try to foresee any legal challenges in court to those laws, head them off the pass, and just be as smart as we can in the crafting of those provisions.
Locally, unfortunately, I don't think that there was any kind of comprehensive monitoring legislation that delegated those tasks to the DOH or the Department of Health, which, you know, is definitely an opportunity for next legislative session, just to plug you guys to engage on elections this summer. It really is, we are at a tipping point in the legislature, and if we can win 3 or 4 races, we have the possibility of ousting Suji and Onishi as ag chair. Hopefully Gabbard stays in as ag chair on the Senate side, and we can start to pass this stuff. I do know that after the disclosure hearings of this year, the Department of Agriculture, the Department of Health, and the Department of Education have agreed to start talking about these issues more comprehensively, and you see that language resurface in the joint fact-finding recommendations, which I think are great. And I do know that the Department of Agriculture is going to increase the pesticide licensing fee in order to fund increased monitoring. But again, that's under the DOA, not the DOH. I am not convinced that here in the state of Hawaii, given the leadership under the DOH and just how much the DOH needs to cover, they're the best for sort of handling our pesticide programming, but they're obviously better than the DOA. And in states like California, where you have better, more health-focused pesticide regulations, you do see the pesticide branch housed under the Department of Health and not the Department of Ag. So it's a very long-winded answer, a way of saying no, not right now, but there can be, and I really hope you guys get engaged.
Great. That was a question from Steve. Steve, I'm going to unmute you, see if you want to follow up. Go ahead. Okay, looks like you might not be able to. So let's move on to another question from Jeffrey Bronfman. George, could you elaborate on the first impression legal standard you've referred to as it related to the decisions on appeal?
Sure. What I meant is simply that there are no cases directly on point that control the Hawaii cases. There are issues of first impression, cases of first impression, where the court decisions in them will be grappling with issues that, you know, we don't have any cases that are directly on point, whether they're from the Supreme Court or another circuit or the Ninth Circuit to look at. So those questions include, but are not limited to, you know, the general issue as to whether or not Hawaii law, existing pesticide and existing agricultural pest laws as a general body in Hawaii implicitly preempt any county laws that cover those issues, pesticides or genetically engineered crops. I think on a federal level, they include whether or not the Federal Plant Protection Act of 2000 expressly, in its express preemption provision, preempts states and or counties from regulating either field trials of genetically engineered crops or all genetically engineered crops, as well as the question of whether federal nebulous policy known as the Coordinated Framework for the Regulation of Biotechnology, which is not a law but a policy, as an implicit matter and as a kind of field preemption matter, preempts any state and or local, that is county level regulation of genetically engineered crops. So those would be some of the questions of first impression. I would say that I think our intervention question is also a question of first impression. That is the Maui Appeal, the appeal of the denial of our intervention. I've never seen a decision, and I don't think one exists, that agrees with Judge Curran that you can compare one prospective party with another prospective party and deny them intervention if you let one prospective party. And I think the case law is pretty clear that it has to be existing parties that you're compared to for the procedure of representation prong on And so I think that's also a question of first impression to some extent. And there's probably others. Certainly some of the certification questions, the reason that we're asking them that they be certified, the state law questions, is very much because they are questions of first impression of state law.
Okay, so what are the next steps? So what will happen if we lose? What will happen if we win? You know, as much as you can kind of discuss that, like what would be the plan B?
Well, yeah, I mean, it really depends what happens. You know, the next steps are we get the argument date, and we have the Court of Appeals decisions in these matters, and then beyond that, it's really going to depend on what the decisions say. Certainly, we're confident. Ideally, we would get decisions that reverse and remand those cases back to the district court for that litigation to continue if there's anything to continue. For example, you know, in the Kauai case, as I mentioned, Syngenta and the other plaintiffs, they raised, I think, 13 claims in that case. So they had a number of other constitutional claims in addition to the two that the court ruled on. So if and when we prevail in that litigation, the case would go back, and presumably the plaintiffs would have to decide whether they wanted to try to continue with their other claims or not. And similarly, in the Maui case and in the Big Island case, there were other claims involved. So there could be, in some scenarios, further proceedings on the merits in front of the district court. As I mentioned, if one or more of the cases was certified to the Hawaii Supreme Court, then obviously the federal litigation would be stayed pending the resolution and the issuance of a decision by the Hawaii Supreme Court, you know, providing guidance on these issues, and then the federal cases could proceed based on whatever the rule was that was decided by the Hawaii Supreme Court. You know, if the cases are affirmed, we lose, then, you know, we'll have to see on what grounds we lose, and then we can figure out what the best avenue is at the Hawaii legislature, in Congress, and of course on the ground at the grassroots level. But, you know, never fear. I think there will be significant progress that can be made regardless. That's one thing that I've learned over the years in doing this work. But it's just hard to say until we see really what the outlines of those decisions are. Obviously, if things are preempted, that's going to really limit our ability to enact similar ordinances in Hawaii and in other places. There's no getting around that. And that's why these cases are so very important in many ways. Certainly there are other things that can be done to try to write things differently perhaps, or enact new laws at a state level, for example, if it's a state law issue that we're talking about. So I think it really does depend a great deal on exactly how the next, say, 6 months to a year, you know, plays out. And of course, once the arguments are held in June, there is no timeline. You know, we could be waiting a while for the Ninth Circuit to issue any decisions, or maybe not. You know, they could issue the decisions very quickly. It really depends on how and when that happens.
Okay, great. Well, we're running out of time, so I just want to ask one more question. Basically, and I think this might be better for Ashley, but feel free to weigh in, George. What resources does CFS or HCFS have that we can share, and how can people get involved?
Ashley, you want to go first?
Yeah, sorry about that. Well, I want to encourage everybody first and foremost to check out our website, which is a sub-page of this Center for Food Safety's website. So it's hawaiicfs.org, and on there you can find all of the materials that we've generated throughout legislative session, including our testimonies, our calls to action. You know, we really need engagement throughout legislative session to keep the footprint of our movement known to those who are elected. So I would encourage you guys to go there. We also have another website, protectourkeiki.org, where we have stuff that's more focused on buffer zones and disclosure. Although this session we've been weighing in on bills that go far beyond just buffer zones and disclosure, including the farmers unions' legislative priorities. We've been working with Native Hawaiian groups on water rights issues, some organics legislation. So that's on our website, but buffer zones and disclosure on Protect Our Keiki. We have this pesticide report that we published last May, and over the past year we've been doing presentations for small and large groups across the state. If you're interested in having a pesticide report presentation in your community, you can contact Allie Coutu, who is our program assistant, and her email is acoutu, A-C-O-U-T-U, at centerforfoodsafety.org to set one of those up. Our Building Power program, as Dania said, is ongoing throughout the year, and it really is our attempt to build capacity within the community to activate, engage, and affect change at a variety of different levels, whether it's getting people to change their behaviors in their everyday life, to changing the way that communities value agricultural land and their health and safety, to tipping policy and legal work. So you can keep in touch with our Building Power program through our email list, which you can sign up for on centerforfoodsafety.org, and we will keep you up to date on all the trainings that we offer year-round. We both do in-person trainings and this webinar series, and so there's multiple opportunities to engage there. Dania, I don't know if you want to just add in any other resources that we have as an office.
No, I think that's great, especially if you go to hawaiicfs.org and click on our legal work. There's a breakdown of all 3 cases, so you get some more information there. You can see my email here if you want to reach out and have any questions. So with that, I will just wrap things up and just say, first of all, thank you to our speakers, especially George, for giving us the lowdown today. And thank you all for being here and taking the time out of your day to join us. If you can, please fill out the survey that we're going to send out tomorrow. It would be really helpful for us to have your feedback and also know what ideas for new trainings that you'd like to be a part of and you'd like us to host. And if you signed up for our membership when you registered for the webinar, you'll receive emails on our next trainings. But if you'd like to stay in the loop, as Ashley mentioned, please join our membership on our website. Let me know if you have questions, and we'll send out the video recording of the webinar tomorrow. Have a great day.